Thank you for joining us today, everybody that is logged in. I see we have like one or two people joining recently, so thank you again. My name is Alina Nuñez, and I am a estate planning, probate, and real estate attorney. And today I wanted to speak about something very important because I am also a mom. And not only am I a mother, I am a mother to a freshly new college student. I was going to say a high school graduate. Yeah, he is. He just graduated in May and he turns 18 in June. And some realities that maybe as parents we didn't hit us. And for me, and this is what I do for a living. But it came that, well, he's 18. He's an adult now. And all of the parents of his friends, I started talking like, well, did you guys know these things? That happens as soon as they turn 18 and they didn't. So I definitely wanted to put a webinar together, let you guys know, inform you guys of exactly what happens once our kids or young adults turn 18 years old. So thank you. Today we're doing the Empowering Parents, Mastering Your Estate Planning and Your Young Adult Future. So as I mentioned, my name is Alina Nuñez. For those of you that do not know me, I am a attorney here based in South Florida in Miami. Specifically, my office is on Kendall Drive and 77th Avenue, close to the Dayland Mall. And what I practice predominantly are areas of specialty here in the firm are real estate transactions, closings, residential, commercial, estate planning, wills, trust, power of attorneys, and probate administration. So if you didn't do your estate planning and you pass away, having your assets distributed. And believe it or not, all three of these things tie in together because some of our greatest assets is our home or properties that we buy as investments. The estate planning protects them from having to go through probate. And then if you didn't, unfortunately, you have to pass through probate in order to be able to do something or sell those properties that you could have inherited. So it's all very symbiotic and all ties in together. So you can read a little bit there about my bio. I graduated from Nova Southeastern University about 23 years ago. And I've been practicing even since then as an attorney, but in general, working in law firms, it's been over 30 years experience that I have. So I've seen a lot of crazy things happen. And that's one of the reasons why I practice the type of law that I do, because I want to help families avoid having these headaches and not being prepared for life. So some of the tools that we use in estate planning, and maybe these are words that you guys have heard, kind of maybe are familiar with. Some of the tools that we use for estate planning are last will and testament, or your will. Intestacy, that's a type of terminology that we use when someone passes away without having estate planning done. Beneficiary designations, those are ways to avoid assets going through probate. And trust. So these are some of the things that I'm going to talk about. At the beginning of this webinar, I'm going to cover mostly general estate planning, and then we're going to dive into the specific focus for our young adults. But if you're parents and you're on here as a parent, as a concerned parent, you not only have to make sure that you're prepared for if anything happens to your young adult, but also for yourself. So that's why we got to cover both and make sure that everyone is protected and we're not dealing with headaches if something were to present itself. So what to expect in this presentation, we'll explore estate planning essentials, helping you figure out, try to maybe make some decisions on, what happens if you pass away or if you get sick or anything like that, and discover how we can protect that legacy that you are creating for future generations. So what exactly is estate planning? And I know a lot of people hear the word estate planning and they think, well, that's for rich people. I'm not rich. And nothing could be farther from the truth than that statement. I hate it when people say that, because anything we own is our estate, whether it's the property you live in, and I don't care if it has a mortgage, you still have equity in that property. That's part of your estate. Your personal effects, your jewelry, your clothes, your car, boats, everything in your home. That is all part of your estate. Bank accounts, savings accounts, life insurance policies, investment accounts. That is all considered part of your estate. So when you start to really sit down and take an inventory, you don't have to be a Rockefeller or a Kennedy or some, a Bill Gates to have an estate plan. Even with something very simple and basic, it's very important to have estate planning, because if not, your loved ones, your beneficiaries, your heirs are going to have to go through a legal court process the day you pass away. You don't want to leave them that headache. Okay. So do I need an estate plan? With an estate plan in place, you can assure that the people that you care about are going to be provided for. And it also gives you control on how you want to distribute your assets. That is the main thing with estate plan. You decide. So if you have a charity that you're very passionate about and you've been very involved in during your lifetime, and you want to make sure you leave something to that charity, you can. And the way that's done is through your estate planning. So here are some essential documents. Again, you've probably heard some of these terms: durable power of attorney, healthcare designation, living will, last will and testament, revocable living trust. So I'm sure a lot of you have heard these. We're going to dive a little bit into what each of these documents mean, how they help, when are they used, what are the pros and cons. So we're going to start off with a durable power of attorney. So this is one of our estate planning docs that is actually used while you're alive. So this is to prepare for the unexpected. I always have a saying, and my kids know it: it's better to have it and not need it than to need it and not have it. I constantly tell them that. Whenever they're like preparing for something or packing somewhere, getting ready for school, oh, do I need to take this? Or, oh, I don't know if I need this. Take it. It's better to have it and you don't need it than all of a sudden you're there, you need it, and you're like, oh my God, I don't have it. And now it becomes a problem. That is exactly what these documents are for. If you are alive and you cannot make decisions for yourself, a durable power of attorney, you're granting someone the right to make decisions on your behalf if you ever become incapacitated, whether through dementia, Alzheimer's, or if heaven forbid you're in a hospital bed because you had an accident and you're in a coma and you can't make decisions. With this power of attorney, if you have these documents already in place, whoever you name can step in and make those decisions. And again, it's who you name. It's giving you that control of saying, well, maybe I don't want my brother to make decisions for me because we have a very strange relationship. I'd rather my sister make those decisions, or, a child or a parent or anything. The point is, it gives you the control to lay out who you're picking to make those decisions when you cannot. While you have the capacity to make decisions, obviously you make your own decisions. So these are only used in that type of situation. The benefits of it is it's easy, it's economical, a power of attorney is affordable, and prevents costly court proceedings if you become incapacitated. And again, the empowering portion is it lets you choose who you want to make your decisions. So if you do not have a power of attorney, what's the alternative? Well, Alina, I don't have a power of attorney. I get this very often. Clients come to me with their parents. They're already getting up in age, and they're like, oh, my mom or my dad is showing, very early signs of forgetfulness, but they don't want to spend the money because they're like, oh my God, to pay that now. Well, no, we're fine, or maybe we don't need it. And then all of a sudden, the day comes that they need it. Mom or dad now has advanced dementia, advanced Alzheimer's, does not have the mental capacity to sign that document. And guess what? They can't do it. They can't. So then what's the alternative? You have to open a guardianship case. So that means we have to hire an attorney. We have to open a court proceeding. The court will approve who gets nominated as your guardian. Now you've lost control. You don't have a say in who it is. The court is deciding together with whoever's petitioning, but they're deciding who is the best fit. And that court will be involved and will be overseeing everything relating to the person until the day they die. So this is ongoing money you're spending to have anytime you need to do something, pay this or do that, you have to get court permission. So it becomes a real hassle if you do not plan and have these documents in place. I tell my clients when they come and sign their estate planning, I hope you will never have to use these documents, but it should give you peace of mind that you have them in case you do. The next document, which is also used during your lifetime, is the designation of healthcare surrogate. So this one is different than the power of attorney because this one deals with health decisions only. And you can name people. You know, if you have, let's say, a family member, whether it be a daughter or someone that is in the medical industry, maybe they're a nurse practitioner or a nurse or a doctor, you can say, well, I want my daughter to be the primary one to make my medical decisions. And maybe your son is an accountant or has more, business experience, then your son would be the one you can name in the power of attorney to make all the other decisions. So it doesn't have to be the same people across all of these documents. Again, it's all about empowerment and giving you the ability of who you name and pick to make these decisions. So who can be named as a healthcare surrogate? And same thing with the power of attorney. Anyone who's at least 18 years old, considered an adult, competent, obviously. And that's really it. They don't have to be a family member. They don't have to be related to you by blood. If you decide you don't want to name, if you have 4 children, you only want to name one of your children, you can. You don't have to. You don't even have to name a spouse. If I do my healthcare, designation of healthcare surrogate, and let's say, I don't know, if you're in the process of, actually, this is a great example that just came to mind, and I did this actually recently for a client. He is at the very beginning stages of filing for divorce from his spouse. But until they are not officially legally divorced, that is still his spouse. So he's like, I don't want her making decisions for me. I don't want her to be the one. So we did his healthcare surrogate, his power of attorney, naming his daughter and not his spouse because he doesn't want her involved. And he had that right. So again, it's all about empowerment and you deciding who you want to choose and having these documents in place in case these issues arise so that you know who's the one that can make those decisions on your behalf, and you are prepared. So living will. Again, this is the third document that we use while you're alive. So the top 3 are the durable power of attorney, the healthcare surrogate, and the living will. The living will is where you are making your decision and you're leaving it known as far as your end of life treatment and wishes. This is a document that states that if you are in a persistent vegetative condition, if you are in a condition where 2 doctors have determined that there is absolutely no medical probability of you recovering from this type of a condition, your wishes are that you be permitted to die naturally and that they don't prolong that process by keeping you connected artificially. This is going to become very important towards the end of my presentation and when we discuss an issue and it's focused on a 19-year-old student at who did not have these documents and what that did to the family and what happened there. So remember that you're saying, these are my wishes. This is what I want done. And in a sense, also it takes the burden off your family. Because obviously, if it's a parent that you're dealing with as a child, we never want to make those hard decisions. But at least if you know that your parent is telling you, this is what I want, you're taking that burden off that child. So they have peace knowing, well, mom and dad said that once they got to this point, this is what they wanted, so I'm going to respect their wishes. So the advantages is you specify your desired and unwanted treatment, avoid family disputes. I have had a situation where a spouse and the children of the person that was in a vegetative condition were fighting. Spouse did not want them disconnected. The children did, stating that that's always what their mother had intended and told them. Unfortunately, this person didn't have a written document, so the children called me, my office, to find out what can be done because there have been 2 days. And I said, well, we're going to have to file a petition with the court. We're going to have to go through all these steps. It's going to cost you a lot of money. Do this on an emergency basis, and there's a possibility that the court might pick go with the spouse versus the children. Luckily, they were able to finally come to an agreement and let that person rest in peace. But these are all the things you want to avoid, and you want to avoid leaving that type of headache for your family. So we've talked about the documents that we use while we are alive in case there were to be anything. Now, the last document is once we pass away. This is our last will and testament. So a will, or also known as a last will and testament, is a legally prepared document that states your intentions for the distribution of your assets and your wealth after your passing. One very big misconception about a last will and testament is that although it is good to have a will, having a will does not avoid your family having to still go through a probate process with the court when you pass away. That is a huge misconception. People think, oh, I have a will. I'm done. I'm good to go. Here it says my house goes to this one, my car goes to this one, and all the money gets distributed this way. That's wonderful. And absolutely, it's great because it does give you that authority. It gives you that empowerment of saying how you want your assets distributed, but it does not avoid probate. You still have to name an executor of your will, who's the one who's going to then go and file it with the court, open the probate process, and have to deal with all of that. So there are better ways to plan and avoid probate. A will is good, but it's not the best. And that's why I always tell people you really should sit down with someone who does estate planning and can tell you the pros and the cons. Because I know a lot of people love to go on Google nowadays. They love to go on ChatGPT. And these types of things, when you just pass away and have a will, you're still leaving a headache for your family. Okay, so there are advantages of having a will. You control what happens with your property. So again, if you have, let's say, 3 children, and for 2 of them you gave them already money during your lifetime, like a living inheritance, but the youngest one, let's say you didn't, and you go, okay, well, these 2 already got their inheritance. I want this one to receive, when I pass away the house. That is what a will lets you do. It lets you control who receives what of your estate. It can save expense and hassle. It can avoid feuding because you are laying out the groundwork and you're laying out your wishes in writing. A will does avoid that the distribution goes based on what the law says. It goes based on your decision. So if you die without a will, it does not go to the state. People say, oh, the state will keep everything. No, that's another lie. You're to debunk that myth. What will happen is that the courts will decide who receives what based on what the law says. And maybe it's not how you want to do your distribution. Okay, so that's one of the advantages. And a will, you control who receives what. A better option to a will, a better estate planning tool that we use is what's called a revocable living trust, or a trust. I'm sure, again, you've probably heard this term. So the major difference between a will and a trust is that a trust does avoid probate, where a will doesn't. But a trust, again, is also a legal document that allows you to transfer ownership during your lifetime of your assets into that trust. You still retain ownership because you own the trust. And then once you pass away, the trust then spells out how your assets are distributed and avoids probate. So a trust is much better than just having a will. Okay, so the benefits of having a revocable living trust is your estate is kept out of probate. It allows for your affairs to be settled more quickly because you don't have to go through that probate process that could easily take up to a year. If your estate is taxable, which currently right now it's any estate with a value over $13.9 million. If it's taxable, there's ways within the trust that you can offset some of those estate taxes. It allows a successor trustee to manage your assets, not only when you die, but if you were to become incapacitated. So while you're alive and you're the owner of this trust, you name in your trust, you're going to name a trustee after you pass away or if you become incapacitated. So this happens a lot where, let's say, mom and dad set up a trust. Wonderful. Years pass. They're getting older in age. They don't have the mental capacity to sign documents or manage their affairs. Now we got to sell this house to pay and put mom and dad either live with one of their children and pay for a nurse or whatnot, or if you have to put them in a living facility, like a senior living facility, anything like that. With the trust, the successor trustee can step in if you as trustee don't have the capacity to. So this, together with the power of attorney, gives that person the ability to manage all of your assets and plan for your benefit because you're still alive. So it has a lot of benefits and a lot of planning for the what ifs. And then it offers protection against court-appointed guardianship should you become disabled. So these are all very important tools and the benefits. A will is a very simple tool. A trust is a lot more encompassing and a lot more protection for all different types of scenarios. So the differences between a revocable living trust and a will: the trust lets you distribute your property privately. That's the other thing. A will is public records once you pass away. While you're alive, none of these documents get recorded, but once you pass, a will does get filed with the court and it is public records and everybody can read it. A trust is private, okay? And a will does not avoid probate, which a trust does. A will, you cannot manage rights or responsibilities or debts. With a trust, you can. So revocable trust can be changed at any time, just like a will and the power of attorney. All the documents that I've talked about can be changed at any time during your lifetime. And you're the one that has the ability to change them. They're your documents. So if you decide today, you want to name your oldest son as the trustee, but then for whatever XYZ reasons down the road you want to change that, you can. Or maybe you name someone and maybe in, few years, heaven forbid, that person passes away. Well, now you have to change it because they're no longer alive and they can't serve as your trustee or as your healthcare agent or anything like that. So trust avoids probate because after you pass away, so long as your assets have been transferred to the trust, then that trustee steps in and now starts distributing your assets based on the instructions that you left and takes care of managing everything for your beneficiaries. Okay. So now let's go a little bit and start focusing on preparing, for school years, for our kids going away to college. These 5 key legal steps, this is for any type, whether it's elementary, middle school, high school, or college. These are all that parents need to take into consideration when their kids are getting ready to go back to school. Update your custody agreement. If there's any parents are having shared custody and there's been any change in that custody agreement, you need to let the school know. Let the school know whether dad's allowed to pick up or not, or mom's allowed to pick up or not, or if there's any type of change regarding that involves the child, you need to let them know. Secondly is review child support arrangements. If there's anything having to do with child support and a change of school, if any payment is being deducted and paid directly to a school, make sure they have all the latest documents and forms in place. Check your health and insurance documentation. Make sure that is all up to date with who is authorized to receive information or not, whether it's from a minor child or a young adult. Education decisions as well. And legal preparation for potential issues that we're going to dive into now with our young adults and making sure we have everything there prepared. So college-bound kids, as I mentioned, mine started on Monday at FIU. He decided to stay local, although I did want him to go away, but that's fine. He likes mom's cooking too much. But a lot of my friends, colleagues, I'm seeing it on Facebook and Instagram, all the, setting up their dorms and sending out their college kids to experience life and become young adults. And that is amazing. That is an amazing experience. And as a parent, it terrifies us because obviously we want to protect them. We want to make sure they're okay. So the best way to do that is to make sure that you have the right documents in place in case a decision needs to be made on behalf of your now adult child. So once your child turns 18, they are legally considered an adult. And parents they no longer have automatically have the right to manage their affairs. My son turned 18 on June 10th of this year. I received a notification on June 10th from Walgreens telling me that effective immediately, I no longer had access to my son's prescriptions. I was like, what? And I'm like, oh, yes, he's 18. That is how quick things are done. And all of these systems that are all tied in, they know based on date of birth and everything. And Walgreens literally kicked me out. I no longer had him in the family group plan, whatever, on the app. I could no longer see his prescriptions or anything. I had to send him an invitation to now approve that I have access to his medications. I'm not kidding when I say this. At 18, they're adults. So here are the 3 focus areas for parents with young adults. We're not going to focus on assets because chances are your kid doesn't really have a lot of assets. They're not owning houses. Some might. But these are the 3 main ones. These are, again, the documents that we talked about in regards to estate planning, focusing on now how it changes for a parent. So healthcare surrogate, again, allows you to make medical decisions if your child is unable to do so. And it's essential for situations where they are out of state or even if they are local, okay? Once they're 18, and I'm going to give you an example of that situation I mentioned briefly of a student at and what happened there, because that really hits home and really is an eye-opener of what not having these documents can mean to a parent. But having these healthcare, and now some questions that I get is, well, what if my child, yes, lives here with me in Miami, in Florida, but they're going to go study in Vanderbilt. They're going to be in another state, or they're going to go to Harvard. They're going to, California. That is fine. If the child resides with you and their residency is in Florida, we do the document here, and those documents are valid in any of those other states. They are there temporarily. They're there for university. Now, if your child is permanently moving, let's say they're not in college and they decide, you know what, I'm going to go move to New York City. I got a job there and I'm going to go live there. Well, then that's different. If they're permanently changing their state of residency for long term, it's not just due to college, then they should have the documents done in the state where they are residing and making sure that it conforms with the laws of that state. What I'm referring to are temporary relocations due to college, going away for college. They'll be back for summer semester or abroad, but it's not a permanent, I'm permanently moving, okay? Living will, as I mentioned, they can, again, make that decision regarding their end-of-life care and leave that known of what those wishes are. And it ensures that their preferences are followed if they can't communicate them. It's all about making sure you let it be known your decisions and your preference. And then the durable power of attorney, as I mentioned, it handles everything that's financial, legal matters, everything that's not healthcare. And it's important for managing your financing and any sort of issues if they're incapacitated, dealing with the college. Let's say, heaven forbid, something happens and they're in a coma in the hospital, and they're gonna be there. They're gonna be, recovering, and it's gonna take, a month or so. With this power of attorney, you can call the university, deal with financial aid, deal with this, deal with that. If they cannot, without this power of attorney, they will, because you are not a student, they are an adult. So these are all situations in which these documents come into play for parents being able to take care of these things on behalf of their young adult and their kids in college. So why are these documents crucial for college students? Because without a healthcare surrogate, you will not have the authority to make medical decisions on behalf of your child if they cannot make it themselves. And if they are in a different state studying and an emergency presents itself and you're not able to make decisions, then either you're going to have to start a court proceeding to be able to be named legally their guardian and their decision maker, or the hospital will do whatever treatment they deem necessary versus whatever your wishes are. And they do not have to disclose information of what is being done. Trust me, as a mother, there's nothing scarier than that possibility ever happening to one of my children. It's critical that they, to have these documents in place if they are in a different state and if heaven forbid would need medical care. Having these documents ensures that you can act on your child's behalf when you need to in an emergency type of situation. It reduces stress and potential legal hurdles during critical times. The last thing you want to be worrying about, stressing that you have this situation with a child, is now you also have to now go to court and try to fight to be named to be able to make these decisions. Okay. And again, these are documents to be used when they cannot make their own decision. This is not a way for a parent to still control their child. Absolutely not. Because so long as that person has the ability to make their decisions trump. Their decisions have priority over yours. So this is not a situation where you're going to go to the doctor and you're there with your child and you're named on their healthcare surrogate and they're getting an opinion about a surgery or a procedure that they need done, and the child wants to, go ahead with it and you're against it. This doesn't mean you can step in and say, no, I don't agree with this. You're not having this done. That's not what these documents are for. That's not how they are to be used. Okay, these can only be used when the person can't make decisions for themselves. And a durable power of attorney allows you to manage their finances and legal affairs if they're unable to do so. Same example I gave, call financial aid, call their bank. If something has to be done with the money in their bank account to pay for something in school or whatever, anything and everything. It's better to have them and not need them than to need them and not have them. Okay, it helps prevent complications in handling financial matters. So this is the example. This is the story that I wanted to bring to you guys, because I used to, in my previous webinars, I used to bring up the big case of Terry Schiavo, but Terry Schiavo's case has been now over 30 years since that happened. A lot of people maybe don't remember, not familiar. And also she was married. She was, 26, not in my opinion, still, a young adult. But it was a little bit of a different situation. She didn't have a healthcare surrogate or living will in place. And then her parents and her husband were fighting because she was in a coma. And for those of you that know the story, unfortunately, you know how it ended. But this one came up the other day in a CNN article, and it really hit home. It really hit home because, again, it is a 19-year-old sophomore at the University of Miami. She was originally, I believe, from either Rhode Island or Connecticut, up north. And she was down here. She had just come down to start her second semester. She was actually pre-med. She was going to study to be a doctor, everything. She went out with some of her fellow classmates to celebrate kind of one last hurrah before school started, and then get in the grind. They took an Uber. She was with some people in the Uber that she kind of knew but didn't know. Basically, from the timelines, they gave her something to drink. The Uber did not leave her where she was supposed to be left. It was about 2, 3 o'clock in the morning, and she got dropped off somewhere and proceeded to be walking in the streets because she was disoriented, possibly drugged, and a car hit her. She was hit by a car. It did not kill her instantly, but she was taken to the hospital and she was in a coma. The hospital proceeded to call her parents, spoke with her mother, and asked, does Bailey have a designation of healthcare surrogate? And the mother goes, no, but I'm her mother. And her mother was a nurse. So very familiar with, the healthcare system. She goes, she doesn't, but I'm her mother. And they said, I'm so sorry. We cannot give you any information. All we can tell you is you need to come down to Miami immediately. No scarier words for a parent. So because Bailey was 19 and considered a legal adult, she had no documents in place. Her parents did not have her sign anything. Her parents had no authority to make any decisions on her behalf. The hospital would release very basic information because they didn't want to violate HIPAA laws, which is privacy laws. And so basically her parents found themselves kind of with their hands tied, not being able to make any decisions. And she was in a coma for 6 days. Her mother kept telling the hospital she was brain dead, to please remove her off, to let her die in peace, let her die. But the hospital said no, because we do not have a living will. And absent any document stating what her wishes are, they have to keep her connected. Luckily for the parents, and I say that with a very heavy heart, it was only 6 days. I have had situations of clients that it's been 6 months. Or the case that I mentioned of Terry Schiavo, if you recall it, it was years that she was a vegetable in bed and her parents and husband fighting, taking it all the way up to the Supreme Court of the state of Florida and up to the Supreme Court of the United States over who had the rights to make a decision, whether the parents, because that's their daughter, or the husband. And the court ruled with the husband, removed her from, once they appointed him, removed her from life support, and she immediately passed because she had basically been dead for that many years. Luckily, in Bailey's situation, because that is agonizing for a parent to see a child in that condition, it was just 6 days, but the parents basically had no ability to make that decision, no ability to make any other type of healthcare decision on behalf of their daughter while she was in this condition, because of the fact that she did not have any document in writing. So if that doesn't open your eyes to the importance of having these documents, not only for our young adults, our children going away to college, but also for ourselves, I don't know what else, could express the importance of having these documents. Another thing I wanted to kind of briefly mention, I know I had shared this webinar through my son's school chats. Again, these are all parents with kids in the same situation. And like 1 or 2 people reached out, they're like, oh yeah, I went online and I filled out some forms with a website called Mama Bear. I am not going to, I don't know them. I don't know. I went on, I couldn't see their forms, obviously, because you have to pay for them. But from my experience with anything regarding legal Zoom, Mama Bear, or anything you find online, they're very, very generic forms. They are not written, they're written by these companies or that encompass all of the United States and might not know, differences in laws within the state that you are in. And they're very simple. They're very, very simple forms. And you don't have someone sitting down with you and going through all the potential what ifs to be able to make sure that the documents that are being prepared are catered exactly to your wishes and taking into consideration, well, what if this happens? What if that happens? Who makes this decision? Or what's this decision? And that way it's all laid out and making sure that they're signed correctly. You download the forms, but then you have to go ahead and make sure that they're notarized correctly, that they're signed by the witnesses correctly. And you have no idea how many forms we get when we have to handle a probate that the wills were done wrong because the person went online, downloaded a form to try to save some money, and now that will isn't valid because it didn't have the 2 witnesses, or it didn't have this, or the notary didn't properly fill out the notary block or this or that. And so now that will is as useful as toilet paper. And we cannot use it. So it's as if that will didn't even exist, or even worse. I've had cases where they've gone to a notary, un notario, not an attorney, to prepare a will. Oh, $2.99, and you can have your will done. And they put clauses or provisions in that will which violate the laws of Florida. But they don't know that because they're not attorneys. So I know I'm an attorney. That doesn't have to just be with me, but please, the one thing I ask, there's two things I'm going to ask. Have your documents done. It is so imperative and so important to have all these documents done, not only for yourself, but also for your young adults. And two, make sure you get them done with someone who knows and is experienced and specializes in this area of law. Okay. As attorneys, we have our specialties, just like doctors do. You're not going to go to a cardiologist if you're having issues with your kidneys. You go to someone who specializes in that. So please go to someone, preferably obviously me, so I'm hosting this webinar, but please use an attorney who specializes in estate planning, is familiar with these documents, can guide you, make sure they are done correctly. To avoid any headaches, so then you don't want to have it done, have that false sense of, oh, I got it, I'm done, I went online, I found it, or I did this, and then when it comes time to use it, they were done wrong. So then that's as good as not having anything done. Okay. I want to thank all of you for attending this webinar, for following us on social media, for watching my videos. I really try to do as much as I can to put information out there, information that's going to help people, information that's going to educate you and make sure that you are protected. As a thank you, I have put together a special young adult college bound package for the living will, the designation of healthcare surrogate, and the durable power of attorney. And I am pricing that at $450. You attended this webinar, you call my office, we have a list of everyone that registers, so we'll be able to reference it, and we will do for your young adult their package of their healthcare, living will, and durable power of attorney for $450 at a discount, which normally we would charge $950. So by attending this, you're saving $500. You're very welcome. And if you want to discuss your estate planning because you haven't had it done, or maybe it's been several years since you had it done, and we can sit down, take a look at it, see if there's any changes that need to be made, we'll be happy to do so. You can contact our office, schedule a consultation, we'll sit down and go through everything with you. And if everything's good to go, then great. You don't need to touch it, but at least you have peace of mind. Or if you've never done it, we'll put something together so that you don't have to worry and leave any headaches for your heirs in the future. So if anyone has any questions that they want to ask, we have about, let's say, 12 minutes left. You can type them in the chat. I will be happy to answer any questions. You're here. You got me. And we'll be able to answer those. Or if there's any other topics in the future that you would like for us to elaborate a little bit more on, maybe do a webinar, maybe a little bit more in depth about trust, or any other topic that you have questions about, we're always open to suggestions. If you don't follow us on our social media, we ask that you please do. Like I said, I work really hard on putting out some really good content in our Instagram, Facebook, YouTube channel. We have all sorts of videos with frequently asked questions and addressing this and addressing that. Trying to educate everyone and make sure that you guys are informed, you're prepared, you have everything in place. It gives you peace of mind, because the last thing that I want anyone to have to deal with is dealing with these very stressful situations, getting courts involved when they don't need to if they just had planned ahead of time. And then on top of that, dealing with a loved one being sick, being in a coma, or in that situation. You already have enough with that. Let's take some of that stress off of you. Let's get you prepared. Let's have your documents in place. So I have a question here. Elizabeth asked, are trusts prepared in one state valid in another when the aging parent has moved? And the answer to that is yes, it absolutely is. So let's say you live here in Florida, you create your trust here in Florida, and you decide to move to North Carolina. You can still, that trust is still valid. Now, what needs to be done is if you buy a property in North Carolina, you're going to then, an attorney in North Carolina will have to do the deed to transfer that property into your trust. I am licensed in the state of Florida. I'm only limited to being able to prepare documents only relating to the state of Florida and as far as legal matters here. So whenever I have a client that has multiple properties and they might have properties in a different state, no problem. I have colleagues, I have a network of attorneys that I reach out to, and I can find an attorney who can help me, help prepare the deed to transfer into the trust. But yes, that Florida trust can still be used and stays in effect even if you move. What I do advise my clients is if you do not have your estate planning in place and you are already planning to move, then wait to do your estate planning in that state. That's your best option. Okay. So if you know in 3 months you're going to be moving to North Carolina and you've never done your estate planning, then wait and then have it done in that state. Next question, Gabby. I know someone that has an older son in his 20s that has a mental health illness and they cannot help him get care because they don't have a power of attorney and he refuses to get proper care. But he is putting his family at risk with his action. How can they get the healthcare surrogate for someone who's not mentally capable to handle his own care? Well, that unfortunately is a situation where they're going to have to do a guardianship. There, if he does not have the mental capacity, then he cannot sign these documents. So if they are truly concerned that he is not taking care of his health, the fact that he can't make his own decisions, we would have to then file a petition and start a guardianship case. We handle those here as well. Would be happy to speak with them and guide them as to what that entails, the process and everything. But that is absolutely the best solution. And what they would have to do is start a guardianship to be legally appointed their guardian. They would get evaluated. That person would be evaluated by 3 doctors appointed by the court to make sure that they can't make decisions. In a guardianship, you're basically taking away someone's rights to make their own decisions, capacity. So the court needs to make sure that they don't have the capacity. And if they are deemed incapacitated, then the person gets appointed as a guardian and we can move forward with that. Hi, does an 18-year-old need to be present in your office to sign docs or can it be done remotely? It can be done remotely. We can do it with what's called a remote online notary. Now, the one limitation with that is when it comes to the durable power of attorney. The durable power of attorneys have what we call superpowers. It's like some additional provisions in it. Again, this is where it's important to sit down and speak with the attorney because maybe if those provisions are not important, they're more like advanced planning, then fine, we don't have to include them and we can do it with an online notary. If we do want to include them, we would have to then we can email the documents, and that means that person can go to a bank or have them notarized. We would schedule a Zoom with them to go through all the documents, make sure where everybody needs to sign, have them taken care of. They would send it back to us. We would review them, make sure it's done before we give them the green light. So to answer your question, no, they don't have to be here. We can take care of it one way or another. All right, so does anyone in particular legally determine that your child is incapacitated? Yes, if you're going through a guardianship process, when we file our petition for guardianship with the court, let's say this comes up a lot and we handle, these on behalf of people with children with either Down syndrome or severe autism. Once they hit 18, they're considered an adult, but if they have severe autism, they cannot make. So there you have to do a guardianship. They cannot sign power of attorneys because they've never had the mental capacity to be able to do so. So once we petition the court, open up a guardianship to have mom, dad named as now adult child's guardian, they will have the child evaluated to make sure that they are incompetent. We never want to take away someone's rights to make their own decisions if they are still competent. It's evaluated by 3 doctors. So that way there's no doubt, as far as their decision of, yes, they are not competent to make decisions on their own. So that's who evaluates and legally determines, and they have to file reports with the court as to what their answer is. So that way the court can decide whether to grant the guardianship or deny. So if it turns out that the person is competent, they're not going to strip them of their rights. And that has happened. I've had that happen where an adult child, wanted to take over their mom's decisions. And they just felt, well, my mom is old. She doesn't know what she's doing. They weren't happy with what decision she was making, how she was spending her money. And they thought that they could just step in and, start a guardianship and take control over her. And she was not incapacitated. And we were able to prove that. And so they denied it. Okay. So these are very serious things that we talk about, and these are very serious things that we're doing to protect, people's rights. So if anyone has any other questions, we got about 4 minutes left. Hope you guys have enjoyed it. Like I mentioned, please feel free to reach out, send us a DM on social media, or message us, leave a comment if you see any of our videos, anything else you want for me to talk about. I'll be trying to do these webinars every quarter on different topics: real estate, probate, other areas within estate planning. Maybe we'll do one a little bit more elaborate on guardianships, especially for parents with children who have severe autism, and planning for that. So you let us know. All right, I don't think we have any more questions, so I'm going to give you back some time. And thank you all again for joining us. Really appreciate it. And follow us on social media. And hope to see you guys soon.